Uh, so I'm Laura Oliver. I am the co-chair of the Family Law Committee. So Logan and I will take turns updating you on family law stuff. We're getting a lot of feedback up here. So as Katie mentioned, we had Lobby Day on March the 27th. In advance, we met with a group of stakeholders and identified a specific list of topics that we wanted to discuss or hear more about from the government. Firstly, we wanted to hear from them in terms of steps that were being taken to improve the portal. We didn't get a lot of information on Lobby Day itself, but from March the 27th to April the 6th, Fola helped host the Justice Services online user feedback session. The primary format of it was question and answer, with the idea being that the feedback would help make the system better. The JSO felt that the feedback was valuable and indicated that staff would be reviewing all of the feedback and sending out a summary. They seem to highlight increasing document size limitations and streamlining user communication with court staff about your specific submission. Their slide deck is available to all associations, and it is a valuable summary of everything that you're supposed to be able to do with the technology. So this will be an ongoing engagement with us. Secondly, we simply wanted to hear from the government on the status of the expansion of the UFC. Again, we didn't get a lot of information. The Attorney General continues to support the expansion, and we will continue to try and push it forward. Thirdly, we wanted to hear if there had been any movement on amending the Family Law Act to get rid of the date of marriage deduction for the matrimonial home, and Logan's going to report more clearly on that because I'm not doing well.
Well, it's a little bit of a Groundhog Day type of answer there. You know, we did indicate that we would like to hear from the government if there had been any movement in that regard. The response from the government official who was present, sometimes I'll name names, sometimes I won't, in this case I won't, was somewhat of the deer in headlights variety. I think that what we're learning is that this is going to be somewhat of a common response from government officials when speaking about family law issues, and this is something that I'll circle back to in general when we conclude. So suffice it to say that we have not had a lot of traction on this issue thus far, but it is something that remains on our radar.
And we then had some sessions with respect to delays in utilizing dispute resolution conferences more, and again, Logan's going to speak more on that.
So just briefly, and this is something that we touched upon at our previous plenary as well, we felt that the expansion of the DRO program would assist in alleviating some of the delays that have been occurring with respect to obtaining family conference dates. We have observed anecdotally, partially as a function of the passage of time and just the fact that it was such an elephant in the room issue for such a long time. The situation, from what we've observed, does appear to be improving, but this is something that we at Fola wish to continue monitoring. There's definitely still likely a lack of consistency across the board, across the province, when it comes to obtaining dates in a timely fashion. But the expansion of the DRO program, we believe, is a good step in the right direction.
And one of our big pushing points was the FRO, and specifically modernization of the FRO, making it more user-friendly. On Lobby Day itself, we didn't get to discuss it very much, but Logan and I then had the opportunity to sit down and have a more engaged discussion, and they had committed to getting back to us, and they did get back to us on May the 8th, and so there are some updates that Logan can share.
Right, so what happened was our conversation was elevated to other ministry contacts, and as Laura indicated, on May 8th, they did provide us with a pretty detailed response outlining some of the efforts that have already commenced and that are already underway to modernize the FRO, such as service email for lawyers as opposed to archaic fax for service, which has been the standard with the FRO even up to the present. as well as an online portal that allows parties to perform common tasks. So it seems that a good amount of the technology, somewhat unbeknownst to us, is up and running, but we would hazard a guess that it is certainly underutilized. And so we think that our next step on this issue will be to look to ways that these existing services, at the very least, can be better advertised and communicated to litigants and to family law practitioners.
And if anybody's interested, we can forward that email that details the sort of technology upgrades to your local president for distribution to your associations. In March, I was asked to participate in a family law roundtable with the Action Group on Access to Justice, hosted by Sheena Weir. And it was sort of a coming together of people who had different novel, outside of the box thinking about access to justice and family law. It was a great session, and it generated a lot of brainstorming, and the Law Society is taking a more in-depth look at a couple of the concepts. Some committees are being formed. Some of the ideas are virtual family law information centers, family law articling clinics, and so those discussions are ongoing, and we will keep you posted.
So I just wanted to speak a little bit about a stakeholder meeting that I attended in December of 2022. So it was a meeting with the outgoing Chief Justice of Ontario of the OCJ, Madam Justice Lise Maisonneuve, regarding the mode of appearances in the Provincial Family Court. It was, I'll characterize it as an off-record discussion, but based upon at least my assessment of the meeting, the consensus appeared to be as follows. One, lawyers prefer to at least have the option of attending court virtually, and court should have flexibility to the extent possible. Two, the hybrid model of combining in-person and virtual court attendances seems to work well. Three, appearances at the front end, such as first appearance court and at least first-time case conferences, often do work well virtually and should continue to be virtual where possible. Four, on the other hand, appearances of significance, such as important settlement conferences or something obviously like a long motion or a viva voce trial, tend to work best in person. And finally, that there's a demand for greater consistency province-wide when it comes to directives regarding modes of appearances. I will say I have not seen much follow-through as yet with respect to what transpired at the stakeholders meeting, but at the very least the court was able to get a clear message from practitioners across the province as to their preferred methodology of modes of appearances in the OCJ.
All right, and last but not least, we've been asked by the Minister of Finance to provide feedback on regulatory amendments relating to the establishment of a permanent framework for target benefit plans under the Pension Benefits Act. The framework, I have to read this because it's a little outside of my wheelhouse. The framework would impact how the value of pension benefits are calculated for multi-employer pension plans. Multi-employer pension plans are pension plans in which two or more unrelated employers participate and contribute to the same plan. So if anyone has any interest in discussing this issue with me, please find me in the hospitality suite, because I'm going to have to take a deep dive into this topic and figure out what all that means.
I thought you were going to say you had to take a deep dive into something else that might be available at the hospitality suite, but that's something we'll discuss at a later time. So I know we're a little short on time here, but we wanted to take a moment to discuss resources for self-represented parties. We believe that tools such as the Mandatory Information Program, or the MIP, are a great resource. However, we believe that more needs to be done to assist self-represented parties in family law. For one, we believe that measures such as publicly available computer terminals in the courts could be of great benefit to self-represented parties. I'm sure we've all witnessed by now, it's not an uncommon experience for us to see self-represented litigants in their cars, for example, connecting to a Tim Hortons Wi-Fi connection, because that's all that's available. And then, after that, they might be admonished by the presiding justice for not being in their appropriate location to conduct the hearing. But again, another story for another day. Brief anecdote, I was recently in attendance at the Brampton Courthouse, and Joanne of the Peel Lawyers Association showed me these amazing booths that they've had installed as a pilot project at their law library at the Brampton Courthouse. They were soundproof, provided privacy, and all the technological resources that were needed to plug in a laptop and get connected to a Zoom appearance. So I think that that's a great example of what it would be great to see across the board, not only for council at practice resource centers, but also publicly available for self-represented parties at courthouses.
That's, sorry, we took up all.
Yeah, I
No
think
time left.
Yeah.
there were two take-home messages that I was going to convey, but I think that we've taken up all of our time, so we'll cede equal time, or what's left of equal time, to Terry Brandon, who's going to give our legal aid update.
Thank you. I know my name's last up there, but on the agenda, it's the other way around, so thanks, Mark. I'm going to take up the rest of the time. He has no time left. Anyways, Terry Brandon, your legal aid chair. How many people in here are still taking legal aid certificates? Let's just start there so I know my audience or who might be interested. Thank you. I want to tell you, Fola continues to participate on the Alliance for Sustainability of Legal Aid. You will see, first time ever, no written report online from me. Why? Why is that? I thought I was going to have good news. I heard from multiple sources there was good news coming the end of April. I thought I could put that in my report and then tell you all about it. If there has been any infusion of money to legal aid, it just isn't known to the stakeholders at this point, and crickets. So I apologize. I thought something was coming. I heard it from many, many, many stakeholders. Nothing. Sorry. Legal Aid, however, has recently commissioned a survey to know the attitude of the practicing bar. We're asked on a scale, are you extremely satisfied? Are you satisfied with your rate of pay? Are you satisfied with the timing of your pay? Are you satisfied with the billing portal? Are you satisfied with legal aid staff? Are you satisfied with legal aid overall? I think no one here doing legal aid is satisfied with the billing portal. It's not friendly, not user friendly, it's time draining, and you're not satisfied that you haven't seen any base rate increase in your hourly rate since April 1st, 2015. But I would think you're satisfied. I'm just asking you, please, take the time to complete the survey. How will anyone know if you don't take the survey? Fola is the voice of the practicing lawyer. We have lobbied the government at both levels. We have attended stakeholder meetings for you. We have had a strong voice. Executive Director Katie Robinette and I have met and greeted with legal aid executive, and we have been told this when we raise our complaints, strong booming voice. We have been told this: the legal aid system is healthy. Lawyers are obviously, satisfied. How does legal aid know this? Because we're all, myself included, taking legal aid certificate work. Legal aid is viable, we are told, and legal aid is sustainable by virtue of exactly that. When I point out that it's not acceptable, that we have not seen a rate increase since 2015, and I raise that, I'm rebuffed to say, again, balance it with your private clients. Wow. Wow. I encourage you, now is the time, take the legal aid survey. Have a voice. Your voice is needed. Shout back. Please encourage other certificate lawyers that you know in your various associations. Encourage them. Take the survey. Last fall, you'll recall, those who were in attendance at the plenary, I wanted to do our own Fola legal aid survey. Katie Robinette, as executive director, wisely schooled me that we don't participate. We don't, all the effort to put out a survey, and we don't get the responses. And that's wise. I hear it. It makes sense. But now there is a survey. So I stress that you take it. And remember what I said at the fall plenary. You'll recall, those who were here. I pointed out with actual numbers then, the annual executive salary increases at legal aid, the bureaucracy, the money spent on internal management, rather than increasing client eligibility thresholds and your hourly rate of compensation. Instead, what has legal aid given to all of us? As of May 1st, 2023, when you go to do your online billing, which already takes an inordinate amount of time, you now must administratively help them with statistic keeping. Statistics that you weren't even aware you needed to keep at the time because it's retroactive. It's without any compensation. And those of you who have been around long enough, you used to get a nominal little administrative fee. It was really nothing. That was removed. Legal aid has now created a billing system so complicated that, frankly, you can't delegate it properly to staff. It's easier to do it yourself. And I hear of lawyers who are routinely working on the weekends, after hours, trying to do their own billings because staff cannot do it. And then you have the whole issue, and I know I'm taking all the time, I apologize. You have the whole issue of post audits by legal aid that consume, again, lawyer time. Speaking out, it's recording, it's a risk, but I believe that legal aid needs to hear from the practicing bar. True case, recently senior lawyer on an audit was called to verify that the lawyer was in attendance in court when the client pled guilty. Lawyer had already been paid, but legal aid secured a number of informations, found 2 informations with defects, and then raised it with the lawyer. Lawyer's name was not on the court information, criminal law. Verify you were at court. Well, that's pretty easy. Look at the information. Oh my goodness, there's no judge. There was no judge at court either. Lawyer points out, there's obviously a clerical error. There's no judge, and I'm not there. Get a hold of the Crown Attorney. Crown Attorney sends an email saying, this lawyer was in attendance. On top of that, get a hold of the senior manager of courthouse staff, have that individual send an email to the lawyer as well saying, I listened to the recording, lawyer was there, and by the way, there was a clerical error, and the judge was so-and-so. Legal aid then writes back to the lawyer saying, not good enough. Order the court transcript. How much do we pay now for courthouse transcript? Get the court transcript, send it off, do all that extra work, staff and lawyer. Legal aid then says, oh, no issue, your payment will stand. That is what we, the practicing bar, are dealing with. What is that? I am telling you straight up, take the survey, please, I beseech you. And if legal aid, just a sec, if legal aid, please, if legal aid will not later on share their statistic keeping with Fola, then let Fola duplicate the survey, send it out, have you take the survey, and let's know the satisfaction, the true results. We need to know, legal aid needs to know. I'm sorry I can't tell you we have an infusion of money like I thought was somehow magically coming. Instead, you have extra billing irritants, and you don't have the money, and you have an opportunity to have a voice on a survey of which I'm not really sure that we will ever know the outcome, because I'll tell you this, for the Alliance of the Sustainability of Legal Aid, we have always had executive members come and participate with us, share with us, and listen to us, and for over half a year, they have not attended our meetings. I don't know what that is about either. Take the survey, let's see if we can get the results, and if need be, let's do our own survey. Thank you. And thank you for letting me serve you.
I'm going to take up even more time, but for the survey, is it sent only to current panel members, or is it to past? Because
I don't know the answer, because I got it and took it, and then I made sure I reached out to many other lawyers, and they confirmed they received it, but I don't know the answer. That's interesting, because what if you're off now because of the problems, and now you don't have a voice?
Yes.
Very
so
interesting.
That was, and when it comes to the billing, one thing that never has made sense to me is why legal aid can't use the OCL portal model. It's much more transparent, but yeah, I definitely would like to get my hands on that survey. Because I know there's quite a few members in Waterloo that we have a senior member who has taken legal aid her entire career and has had enough. So yeah, I just want to make sure that people that are no longer on the panel also have access to that survey.
Is it possible, Terry, to have the president follow up with you and then they can distribute it to their members?
I can look into that. There's an email. I can also look into whether or not past members can receive the survey. Thank you. Interesting. Thank you.
On the legal aid note as well. Also echoing the comments about per diem duty council, and I'm not sure if it's called this everywhere, but we have the FLIC, the Family Law Information Center. Yeah, so to include them as well. But I'm also...
Could you do us a favor when you come forward, identify yourself?
Oh,
so
yes,
everyone
absolutely.
In the room knows
Sorry.
and...
I was trying to sneak in, but I didn't do a very good job.
That's good. No
I'm
worries.
Jessica. I'm from Sudbury. I represent the Sudbury District Law
Thank you.
Association. I split my time as a family law private practitioner as well as a member of one of our local legal community clinics. The legal clinic in our community is super important, and in a lot of other small communities is super important. So I just think maybe in the future it might be cognizant to focus as well on the legal aid clinic side of things as well as the certificate side of things. And my commentary on that is just because a lot of our membership from Sudbury and the surrounding areas are members of these clinics and have worked in these clinic systems for a long time, and they really have a good understanding of what the needs of their base are, but as well as how the funding issues overlap. And there's a lot of work that's being done on funding by the clinics themselves. So I think it's a good opportunity not to duplicate work if we can work together in some ways.
What's your first name again?
Jessica.
Thank you, Jessica. We've had a very strong presence from the clinics, very strong at our lobby day, and we're well aware of the clinic side, and the clinic side also has a very strong representation at ASLA as well. I know the floor is not open to questions, so Katie is going to come up and scold. I'm going to get scolded.
We have time for one
This is your break.
One quick question, and then we'll get to Mark, and then break time.
I just wanted to check, is the survey through the legal aid portal?
I don't know. It was sent out by email, but I'll check and see if it's actually on the portal for anyone to access, because that would then address the duty council and past members. It's an excellent point. Thank you. It was sent out by email to certificate lawyers. Thank you, Mohammed.
It could be that only active panel members receive the email. I'm wondering, but Terry will follow up on that.
All right, Mark, you're up. You're up. You got 2 minutes.
Follow that, Mark.
42 seconds. Here we go, everybody.
He told me his is 2 minutes.
Just so that you're aware that real estate lawyers will soon be taking legal aid. I just wanted to give a brief overview of the year in review over the last couple of months. We've seen strange trends in the markets. We've seen interest rates do things that people haven't seen in years. Software applications are doing interesting things with their pricing, including new and innovative counter solutions being emerged into the marketplace. Challenges with staff retention, challenges with lawyer retention, demands on lawyers needing specialized expertise, and an increase in lawyer claims. Why are we practicing real estate? Well, it's still happy law, and it's still good stuff. And it's still the gateway to a whole bunch of other legal services that are the front lines for a number of people who are looking to have access to legal affairs. So it is a very key and ongoing issue that we do need to be mindful of. part of what we do here at Fola is to identify those issues and address them properly and informatively to the various players that impact how we practice real estate law, how we deliver those services, and how we can continue to be expert in the delivery of those services. It's not a race to the bottom. It should be an acknowledgement of the services that we provide. We continue to refer you to the suggested fee schedule for the working group and to utilize that in your day-to-day practice as a fair and equitable means of identifying a basis to compensate yourself for the work that you provide to your clients. The key regulatory change or update in 2024 is the ID identification and attestation rules. We were successful in getting a reprieve of sorts for about a year to better appreciate the changes that are coming to realign how we practice, to identify our clients, to identify red flags, to appropriately address the issues of those that are using lawyers for real estate transactions. So that should be an effort focus on each of your associations to ensure that you don't wait until December to figure out how these rules should be implemented in a day-to-day practice. They should be you should be implementing them now before the deadline comes about. The Director of Titles has issued a number of releases and updates in terms of best practices for the utilization of the TerraView system. There will be a consultation process in the next little while asking members and users of TerraView and OnLand to demonstrate how it could be a bit more modern, efficient, reliable, secure, or user-friendly. So we will have touch bases on each of those components asking for input so that we can take it back and potentially improve the system. We advocated in connection with the changes to some legislation, the Planning Act amendments that came in earlier this year, and also the implementation of the prohibition on residential purchases by non-Canadians, a federal legislation that prohibits non-Canadians from buying residential property in Canada. Big controversy over the implementation of it. It was written in crayons by a 3-year-old and just didn't seem to achieve the policy that it intended to do. That had been modified by regulations in March that helped to fill in some of the gaps. So managing that on a daily basis. Through Lobby Day, we also advocated the possibility of modified repeal of the law on positive covenants for various projects or land assemblies or land arrangements that have co-ownership shared services that are not condominiums. Disaster falls by virtue of the fact that positive covenants don't run with the land. Very academic, but actually causes a lot of problems for a lot of people. So real estate, everything is changing almost on a weekly basis. We do continue to monitor that. We do appreciate receiving your concerns, your inputs, and your suggestions so that we can amplify that and really get a voice out to those that really need it.